Good morning, counsel.
Good morning, Chief Justice. May it please the court, my name is Andrew Don, and I am the CPCS-appointed attorney for Erica, who was herself a child in the custody of the Department of Children and Families and is the mother of Isabelle, and who is present here today. On behalf of Erica, I'm asking that this court vacate the order of the Justice of the Juvenile Court awarding temporary custody of her daughter to the Department of Children and Families. And I'm asking that on two bases. First, I'm asking that, suggesting that under Chapter 119, Section 24, which requires that when a child is to be transferred, custody of a child is to be transferred to the Department of Children and Families, that there must be a showing of serious abuse or neglect, or that the child is at immediate risk of serious abuse or neglect. Neither of those circumstances were present in this case, and that the judge was clearly erroneous in concluding that there were. In this case, there was essentially two allegations against the mother. First was one instance of what was described as a pop, and then later again as a smack that was heard in another room by a foster mother.
But it sounded like there was a long, well, it couldn't be, I mean, I know this is a very young child, but there was quite a period of time, two different foster homes, different people observing the interactions of the mother and the child, and so that, I guess this is what I'm asking, does one just discount that and focus only on the smack heard in another room and
No, I think,
else?
but we have to, the justice must apply the law. And the law is that there must be serious abuse or neglect.
It can be emotional abuse, however. It doesn't have to be physical abuse.
Well, certainly I think we can imagine an instance of emotional abuse. There is no, to my knowledge, regulatory or case law guidance with regard to care and protection cases about what the content of emotional abuse actually means. Again, I think it would be very easy for us to imagine situations where a justice could draw that inference reasonably. I don't think that's this case, Your Honor, and for this reason. The emotional abuse is apparently alleged by the, or found, excuse me, by the justice, is that the mother was yelling at this child. And the evidence that came in was that on 3 days a week, sometimes 4 days a week, mother would yell in frustration at her child, and she would
But
yell.
one doesn't have to use very much imagination to infer that if the foster mother had not been present in each of the two homes, that the situation would be would have been much worse between mother and child.
That was not a fact or finding drawn by the justice, for one. And second is, I think it's also important to remember that in both of these foster homes, through no fault of Erica, the mother, that both these circumstances were compromised by outside circumstances. So that in the first foster home, the foster mother testified on the record that the illness of her daughter took her outside of the home and it put added stress and pressure on the foster home situation. I think it's also important to recognize that in that first foster home, during her testimony, she never said that the yelling had an adverse effect on the child Isabelle, but that it was too much for her and her family. And I think when you consider that in conjunction with the added compromise of the illness of her daughter, I think that's something that's important to remember. That foster mother never filed.
So what happens when Isabelle gets sick? There'll be added stress on Isabelle's mother. I mean, things happen.
Precisely, and that perfection here is not the standard, but that the child is at immediate risk of serious abuse and neglect, and that just wasn't the case here. Some instances of yelling, again, not perfect parenting, but not of the kind that the department should be willing to remove children from their parents in these particular circumstances.
Maybe there's an overfocus on a slap, but maybe, and maybe it's not even emotional abuse, but neglect is very serious and has long-lasting consequences, I think, that are sometimes overlooked. And here you've got a very young child already seemingly responding to a mother who, perhaps for reasons not entirely within her control, having to do with her own background and youth. And again, we're still at the early stages here, really needing some intervention. We'll set that aside for the moment. But this child is out of control in her ability to control herself because of the inability of her parent to control herself. And that's neglect.
I don't think that's the reasonable inference here, Your Honor, is that it's important to remember that Isabelle and her mother were separated from one another for 10 months prior to this reunification. Isabelle, by the testimony of the foster parent, came into her home with these behaviors. So the mother, Erica, is inheriting, if you will, this sort of pre-existing situation, which she's now being asked to deal with and be accountable for. And I think that the testimony is that she had at least mixed results with regard to that. She was able to appropriately set limits. She was able to discipline her child appropriately, at least at times.
Are you saying that the single justice in denying your relief committed error of law?
Yes, because in affirming the error that was made by the trial court.
Of not meeting the standard that is required for a 72-hour hearing?
Yes.
So what would you have us do now at this stage?
At first, I would be asking you to find that as a matter of law, there was not a sufficiency of the evidence for the judge to conclude what she concluded. And therefore, I'd be asking you to vacate the order and return custody of the child to her mother. In the alternative, I would be asking you to remand the case for I'd be asking you to remand the case, and that the child and the custody be returned to the mother, and that the case continue in the usual course, meaning that at some point, which it has not yet been done, be scheduled for pretrial conference and then for trial.
There's nothing since this has happened. Nothing has happened in the case itself, because this is an interlocutory hearing.
If you look at the docket that's provided in the record appendix, I had filed an abuse of discretion. No action was taken on it, and the judge has indicated that she will not take any action on the case until this issue is resolved, because it's possibly dispositive.
So where is the child right now?
The child is in a foster home apart from the mother.
Has been for how long?
Since the removal.
It was May of 2010?
Yes, May 24th.
How old is the mother now?
The mother has now turned 18. She turned 18 in July of last year.
Can I ask you again about the second part,
Yes.
at least for me, is are you assuming that the two foster placements, which everybody throughout the documents seem to say were particularly selected to provide a certain kind of guidance, okay? That seems to be an assumption, and yet I cannot find what it is that these particular individuals, other than having been qualified as foster parents, have in terms of specialized expertise in order to train someone who needs it. One, for example, was only 3 months prior certified as a foster parent. There doesn't seem to be any indication that there is any specialized training except as a parent. Is that not an issue?
I think it is an issue. And further, I think what's important is to recognize is that the department itself conceded, contrary to what the department argued in its brief, that in addition to being placed with these particular foster homes, even with them being placed, the department still felt that a parenting class was required and also a parent aid. So I think the department has conceded itself that these were not sufficient services.
And that they were available perhaps only in the kind of places that may have come available at some point in Cape Cod, the kind of,
Yes, and I think the other thing that's important to remember here as well is that when a young mother like Erica, who is in the custody of the department, gets moved, all the services have to be transferred. In this case, it was from Dartmouth, to the Cape. There's a lag time for which she can continue to make use of the services, for those services to begin, and for her to continue the progress that she showed, albeit somewhat bumpily along the way, but she was showing progress. In conclusion, this mother was not dangerous to her child. If you look at the Cobble case, and in comparison to this mother, this mother was not dangerous. Further, I would ask you also to consider my argument regarding Chapter 119, Section 29C, that the department did not make reasonable services prior to removing this child as is required by the statute. Thank you very much.
Thank you, counsel.
May it please the Court, Richard Salcedo for the Appellee Department of Children and Families. I'm also arguing today will be is the Child's Counsel. Your Honors, the evidence presented during the hearing, the 72-hour hearing, did in fact demonstrate by a fair preponderance of the evidence that the child was at risk.
What evidence are you referring to?
Well, Your Honor, what the evidence indicates is that the child was in 2 successive foster home placements between January and April of 2010. Both foster parents testified that they observed mother on a regular basis experiencing frustration and engaging in what they described as screaming matches with her 2-year-old child. This occurred on a regular basis, and despite the fact that the foster parent continued to provide the mother with daily advice and suggestions regarding adequate or appropriate parenting techniques, mother's behavior did not improve. The social worker also intervened and spoke with mother about these concerns on a number of occasions, and her behavior also did not improve. The social worker also observed mother have an outburst, an angry outburst in her presence with the child in her lap. Mother tore up some department documents, screamed, and the child, according to the record, was upset and was crying. And there was a progression that occurred in the second foster home. The second foster mother also observed the same type of behavior, the same pattern continuing. And she noted that mother experienced daily frustration, and the more that she experienced the frustration, the more physical she became with the child. And she also noted that mother failed to recognize the poor quality of the child, of her own behavior, having any effect on the child's own behavior. And there was evidence in the record that the child's behavior improved when, during instances when the child was not in mother's care but was in the sole care of the foster mother. This all culminated with a 51A being filed, as was mentioned earlier. The foster mother noted in the 51A, which was filed as an exhibit, that the child had become rough the minor parent had become rough with the child, was dragging the child into a bedroom on one occasion, and that she had overheard a smack and the child crying inside the bedroom.
Counsel, can I ask you, what's the plan here? Is the department seeking reunification, and what steps have been taken in that regard?
At the time of the 72-hour hearing, the plan was for the child to be reunified with the minor parent. After the mother was removed, she was placed in a separate foster home. The child remained in the foster home where she was residing at the time, and mother was on a waiting list for a teen living program. She had previously rejected a placement in a teen living program, according to the record, and that's why she was placed in these 2 different foster homes. So that was the plan at the time, was to reunify the child with mother in a teen living program as soon as a placement opened up at one of the programs.
Is that still the plan?
You're using the past tense.
Yes.
So.
I have spoken to trial counsel, and mother has turned 18, and despite the fact that the department has urged her to remain in the department's care, she refused to do so, and she is on her own now and is residing in the home of a relative. And we have changed the goal. The child is now in a different foster home, and the goal has changed from reunification to adoption.
Adoption by the new foster parent?
I'm not sure. I believe so, Your Honor, yes.
And she's been in one foster home since whatever it was last spring until now, May?
She's in a different foster place
No,
now.
but it's one home continuously for the last
No.
10 months? No?
No. She was in that home after her mother was removed and placed, but now she's been moved into a different home, and I'm not exactly sure the date of the...
And you don't know which family seeks to adopt her?
I don't, Your Honor, I'm sorry.
But there is a family that
Yes,
seeks to adopt
apparently.
her?
I'm sure
Thank you,
Child's
Counsel.
Counsel.
Thank you.
If I could just one very quick point just to mention, because counsel had raised the issue of the reasonable efforts requirement under 29C. This court just decided adoption of Alona and decided that the department had made the argument that even where the department had failed to meet the obligation of reasonable efforts, that the court, under the statute, which is the last sentence of the statute, that the court is still able to make orders conducive to the child's best interest, even where there is reasonable efforts have not been made. So adoption of Alona addresses that issue. Thank you.
Thank you.
Good morning.
Yes, ma'am.
May it please the court, I'm Lisa Sheehan here on behalf of the, Isabelle, I'll call her. Two factual matters I just would like to clarify. One is that the two foster mothers who testified at this hearing were the last two foster homes that the mother and the child were placed in together. They were actually the third and the fourth. There was an original placement. That foster mother did not testify at the hearing. However, the docket entries reveal that mother had custody of her child. And then the teen living program that was referred to that mother had disrupted from was actually the first placement that they had been in together. So this was the fourth placement, and as Justice Botsford pointed out, there was quite a pattern of disruption in Isabelle's life and in the mother's inability to implement the techniques that had been taught to her by parenting classes, by each one of these foster mothers. And the other piece I would like to clarify is my brother's argument that the foster homes were somehow compromised and that was somehow conceded. There was a brief period of time in the first foster home that one of the children was sick, and I think it should go without saying this mother was required under the terms of her agreement with the department and along with her obligation as a parent to take care of her child. And again, it was the pattern of she was able to implement some of the techniques for a short period of time and then deteriorated into periods of time of emotional and, yes, physical abuse. And I believe that the department met its burden on that point.
Is there any, at the moment, is there any visitation that's going on?
There is, yes. I'm going outside the record, but I believe that it would be, I think the visitation has not changed.
And has the child been in one foster home since May until now, or not? More than one?
Again, I would be going outside the record. She did, I believe, remain in the fourth foster home through the summer, and then for unrelated reasons, that foster mother gave her notice. The department sought another placement, and it turns out, subsequent to that, changed the goal in the case to adoption.
And is there an adoptive family or
There
parent?
is. That's where she's placed now.
Where she is placed now. Okay.
And that was just before Christmas, I believe she moved there. I'm sorry.
So what's going on with, I mean, is there a termination proceeding ongoing? I mean, what's the next step here?
As my brother indicated, the juvenile court case has been somewhat
Stayed?
not formally, Your Honor, but yes, there hasn't been anything heard. We are in the court tomorrow for a report on this matter, although it was coincidental with the argument. The matter, my understanding would be the department would be pursuing termination, and a pretrial conference would be the next piece to be heard in the juvenile court. Although my brother has, as he indicated, filed a motion for an abuse of discretion, indicating that the mother and the child should be placed together. And
What is an, pardon my ignorance, but what is a motion for abuse of discretion?
I'm sorry, Your Honor. My brother is challenging the department's placement of Isabelle and her mother separately, and that was
It's
An abuse of discretion by the DCF, not
Abuse
by
of
the
di-
judge.
That's right, abuse of discretion by the department that they have not provided what the services that are necessary. Prior to that motion, however, I would like to point out that in the record below, Mother did not ever indicate that additional services were needed. The services that my brother referred to, the parent aid and the parenting class, those would be available in the teen living program, which the department has concluded would be the most appropriate placement for this child and the mother, given the number of placements that have disrupted. So it was not that list was exhaustive, as the department was just conceding that those two services were all that this family needed, rather that the teen living program provided lots of things that weren't available in a foster home. So I would ask Your Honors to affirm the juvenile court order, unless there are further questions. I'm sorry, Your Honor.
Yes, I have some questions. Just trying to understand. You concede that the teen living placement seemed like a good idea. It offered numerous advantages to, and now I'm making an assumption, to the kind of guidance that you think provided her with techniques of appropriate parenting. I don't know what they were. I don't know how they were taught. I don't know whether it's been substantiated that they work, or even if they work, that they can be taught in the way they were taught here, with limited intervention and some suggestions. So up to a point, at least where our record stops, she was agreeing to go to the teen living. You say disruption, but certainly there was some indication that she didn't want to go back to the old one, was willing to go to the new one.
And was on a waiting list for that,
Right.
or for two. I'm not sure if she had agreed to a specific teen living program. She was on a waiting list for
Right.
three teen living programs during this hearing, one of which she had already been placed in and had already refused to go to prior to the C home. There was an opening.
So
before.
there was some reason, unclear why, but not an absolute disagreement was going somewhere.
The department had
Well,
not willingly, or had compromised with the mother in placing her in one of these foster homes, as opposed to the opening that had occurred in the teen living program.
I
And
thought it was an appropriate thing to do
They
at that
thought-
time.
they would try it and see if it would work out with the experienced foster mother, and then a much younger mother, but a mother with a child just a little older than Isabelle was at the time, to provide modeling. And they thought that they would try that because the mother was refusing to go, basically. If there are no further
All right,
questions.
counsel, thank you very much.
Thank you.